Good afternoon and welcome. I hope everyone can hear me well without microphones in this room. And welcome to the Center for Global Affairs. We are today discussing a very important topic of international human rights law. But before to do so, we have some welcome introductions. And the most important one comes from our Dean, Professor Caroline Kissan, who is Associate Dean here at the Center for Global Affairs. And thanks to her, we have this wonderful venue. So today we discuss counterterrorism, human rights, and the independence of judges. It's a panel discussion that starts with looking at a very specific case that is absolutely overlooked, the situation in the United Arab Emirates, and trials that I'm sure some of our speakers will be able to enlighten us about. This is not a law faculty. We are proud to be in the intersection between many areas of learning and knowledge. But today, I must say, we have really the GOTA of the New York City lawyering, because we have the New York City Bar Association co-sponsoring with two committees and one task force. I will give them the floor. And also we have prominent jurists coming from also the other side of the Atlantic and the judicial bench. We also have political scientists and geostrategic and counterterrorism experts. They will also speak. And above all, there are a lot of my students and former students who are doing important jobs. So without any further ado, I thank the most important partner to this event, which is the Student Association in Global Affairs, SAGA, here represented by Shruti Dixit Misula, who's the president of the association, and we will not exist without the students and the Students Association. We will not exist as professors and lecturers. So, Professor Kissan, please.
Well, you're so kind. Thank you so much. A very warm welcome to the CGA, as we call it. It is really an honor to have you all here and to be hosting you for this very important conversation. I should point out that David has been teaching at the CGA for over 10 years. Just exceptional, really an exceptional member of our faculty, teaches our international law course. I think many of the students in the room, former students, have taken this course. A real just gem in the classroom. So really delighted to have you here and to be able to host this conversation. David has already sort of highlighted all of the people that are part of co-sponsoring this evening's event, also to the students who are joining. And I should add, in our at the CGA, we have a concentration in transnational security, and counterterrorism, of course, is a really important area. Not only do we have our transnational security concentration, but we have also international law and human rights. So today's conversation in terms of counterterrorism, human rights, and the independence of judges very much intersects with a lot of the work that we do and our students do. In fact, I'm looking at a couple of students who just recently graduated and took on really challenging topics for their thesis and capstone projects. So today's conversation and the discussion that you're going to have is also really critical for the students in the room to be able to kind of understand that you who are working every day in it, what are the questions, what are the ongoing sort of challenges, and how they can be involved and understand, because they will be active practitioners, which is something that we really seek to do every day at the CGA, is to make sure that what we're teaching in our classrooms reflects what is happening, as we say, in the real world. There's a lot happening. So I'm really delighted to have the opportunity to also sort of be an observer. I do issues of energy security and geopolitics, so I will be an engaged observer. That really grateful to have the opportunity, and thank you so much, David, for all of your work, as he has really been the source of power behind bringing this all together, and we are just happy to have the opportunity to be a part of it. So
thank you, Caroline, and I believe that this school is very dynamic as an approach that covers so many different areas of legal knowledge, and certainly the concentration on human rights and international law is one that still maintains a very, very significant space here. So without further ado, I am happy to give the floor to the chairperson of the New York City Bar Association Independence of Lawyers and Judges Committee, Christopher Pioch. Am I right?
Yes.
And Chris, please.
Hi all, my name is Chris Pioch. I chair the New York City Bar Association's task force on the independence of lawyers and judges. By day, I'm actually a commercial lawyer, so I'm one of the legal delegates here. By night, I do all of this wonderful human rights work. I'm very happy to kind of present a little bit on this panel on counterterrorism, human rights, and the independence of judges. And I just want to thank all the panelists here. I want to thank NYU for hosting this. I'd like to point out and thank my colleague on my task force, Judge Lisa Ridgway, who is going to be one of your panelists this evening. She is phenomenal. She is one of these people that just is a dynamo. Her commitment to the independence of the judiciary is renowned. So you're very lucky to have her. Let me just start by noting that the New York City Bar Association was founded upon the principle of an independent judiciary, because the founders, they recognized during a time of corruption and the dissolution of public trust in the legal profession and the judiciary that you needed to have that component of public trust. Public trust is essential to judicial institutions. And I believe that public trust is crucial to maintaining the integrity of these judicial institutions in discussing anything involving counterterrorism. So in 2019, I'll just point out that the Global Counterterrorism Forum stated, and I have a quote here, "A strong and independent judiciary that fairly and expeditiously adjudicates terrorism and other national security offenses is critical for public confidence in the legitimacy of judicial institutions, is an effective deterrent to terrorism, and minimizes the risk of violations of fundamental human rights." Now, my task force at the City Bar has spent nearly a decade monitoring threats to judicial institutions and to the legal profession as a whole. In that time, we've documented what I would describe as a global chilling effect to our judicial institutions. Judges are targets simply because they're doing their job of weighing the evidence and evaluating the laws. In extreme cases, judges have been charged with being members of terrorist organizations or complicit in terrorism. In other cases, political rhetoric accusing judges of bias has served as a pretext for wide-ranging judicial reforms that alter the makeup and role of the judiciary. This is happening worldwide. Without a strong independent judiciary, the lawyers working in these institutions are also targeted. In the most extreme cases, lawyers have been tortured, killed, or face imprisonment, but oftentimes they're subjected to other kinds of harassment and ostracization simply for representing an unpopular client. So today's conversation is an important step at really getting back to basics. Independence means that judges must make rulings by evaluating the evidence that is presented and by partially applying the law in order to ensure the fundamental rights of case participants, litigants, are protected. Independence for lawyers means that the lawyers are free to represent their clients without compromising their own safety, their family's safety, or compromising the protections that are normally afforded to their clients. In short, let the judges do the judging, let the lawyers do the lawyering, and let them both work to maintain a system of due process. So thank you all. I'll turn it over to my colleague Ramya, who's chair of the Human Rights Committee.
Hi, good evening. My name is Ramya Jawahar Kudekulu. It really is such a pleasure and honor to be here. And I think given the context of our times, really imperative that we have these conversations. I want to talk a little bit about my committee and then perhaps close my room so that you can hear from my colleague to the right. So in my committee, the International Human Rights Committee within the New York City Bar has a long history of looking at issues from the human rights perspective, specifically the International Human Rights Framework as we know it, which is conventions, treaties, customary international law and other interpretations by international forums. And part of what our concern has been in terms of focusing on counterterrorism policy and law is the examination of what it means when there is a misuse, a systemic misuse of law and policy when it comes to discriminating against certain groups or certain individuals who have certain identities. And so one of the things that we want to talk about further is how counterterrorism policy has really been adversarial to the construct of citizenship, and how at this time and age, citizenship inherently is at risk, and citizenship being sort of the pedestal on which one has rights to have rights, or is the right to have rights. And so our concern as we look at these issues and how they unfold in different parts of the world is that we're unraveling citizenship rights, we're unraveling protections that are associated with citizenship, and we're also hitting hard at the possibility of those who are in limbo in terms of either unable to access full citizenship or unable to establish a relationship with a state, either because they're an immigrant, a refugee, or part of a population that is considered suspicious by the state, who no longer or may not ever have the ability to form a secure construct of citizenship or nationality. I want to put things in a little bit of context for us, and I want to quote directly from the 2023 UN Special Rapporteurs on the promotion and protection of human rights and fundamental freedoms while countering terrorism report, which says that we are left currently only with 3.2% of the world's population living in countries with open civic space. 11.3% in these countries, of these countries, civic space has now narrowed. 14.9% of these countries, civic space is obstructed, and 42.2% of the world, civic space is repressed, and 28.5% of the world's civic space is absent, which is dire. And let me narrow that down to say that many of us, either through our work, our association, our scholarship, our public discourse, in another country and in another jurisdiction would be considered targets to counterterrorism policy and law, and would be considered reasonable suspects. And so I want to leave you with a small poem that was written by a human rights defender who's currently incarcerated in India and was incarcerated as a result of human rights work, but then was targeted or charged under a well-dusted off counterterrorism law that is now very actively being used by that state. And this is Hani Babu, and Hani Babu's letter to his family, 12th of October, and the letter contains a poem. Dear Sachi, not as beautiful as it is outside when it is inside. This rain seen through the windows of a jail, it's not like you described. The rain does not rain through glass pipes, the scars on these terraces. There is more to this than your little angels can ever wipe. There is not even a single tree in here. Even then, they have not been able to take away from me the music of this rain, or the silence of deafening sounds of thunder drums. So I lie here listening to this rhythm, on this floor where rats and centipedes crawl. I lie in the warmth of these rough sheets, not worrying about fundamental rights or basic freedom. I think of my daughter, who used to wait for me to come home every night, and now you, who is bearing the burden of the house. Thinking that I'm not alone in this iron-barred prison, I go to sleep in this prison now, dreaming of a country where our fundamental rights and freedoms are not snatched from us, and where we can sit watching the glass pipes of the rain. Thank you.
Thank you, Ramya. And your colleague, Chris, deprived me of the opportunity to introduce you because you teach international law.
I do, right next door at
Cardozo Law School. And I think what you have said about the fact that a person like me, for example, will not be able to travel freely in a number of countries of the world, which is evidence of that, signifies that counterterrorism laws are used against those who are criticizing those in power. This brings me to the last opening speaker, Professor Sofia Murakowski-Roma. Is co-chair of the New York City Bar Association United Nations Committee. And this is where everything comes from here, because our starting document is a document from the United Nations. She's also a legal writing specialist, at the Turo University of Law, so another great faculty here in the city. Sophia.
Thank you so much, and I'm honored to be among such expert minds. My name is Sophia Norkowski Roma, and I'm an international human rights attorney and the co-chair of the United Nations Committee. Also the former counterterrorism, extremism, and anti-Semitism fellow at Human Rights First. And the United Nations Committee of the New York City Bar Association upholds the commitment to highlight the impact of counterterrorism measures on civic space and on civil society. And it remains imperative that terrorist narratives are addressed in compliance with existing human rights standards. So obviously there is a need to promote and to safeguard human rights as well as to protect our fundamental freedoms while countering terrorism. And hence this event featuring our expert panelists is crucial during these trying and turbulent times. So both terrorism and counterterrorism are the United Nations Committee and the UN obviously deem as human rights issues. Terrorism is a human rights issue, for it involves deliberate attacks on civilians causing death and serious injury, and in that vein engages the right of life and the right to physical integrity. So counterterrorism is a human rights issue for the manner in which the state responds to the threat of terrorism, which may involve exceptional measures that depart from well-established legal principles, including fundamental rights. Now, if you will indulge me just a little bit, because I'm a academic sort of soul, and I also practice in legalese and legal language, I'll just read to you what I've prepared. Today, our focus is on international humanitarian rights law as it applies to measures against terrorism, which reference to global examples of legislation and state practice in countries such as Algeria, China, Indonesia, Israel, Jordan, Pakistan, Peru, the Russian Federation, Spain, Sri Lanka, Swaziland, Uzbekistan, Yemen, the UK, and the United States. And that's all of what encompasses our United Nations Committee of the City Bar. So we must first consider the duty to prevent, investigate, and prosecute terrorist attacks before turning to findings of intergovernmental and non-governmental organizations, as well as analyzing legislation in translation, depicting those violations of civil, political, economic, social, and cultural rights which are committed worldwide in the name of counterterrorism. These violations, obviously, include arbitrary deprivation of life, torture, and cruel, inhuman, or degrading treatment or punishment, and forced disappearances, arbitrary detention, unfair trials, disproportionate interference with civil and political rights, and discrimination. So I want to draw attention to the dual imperative of ensuring individual criminal responsibility for terrorist attacks and for substantiated violations of international humanitarian law and international humanitarian rights law committed in counterterrorism by concentrating on accountability in reference to criminal trials, civil suits, independent national investigations, and intergovernmental reports that can address impunity, combat secrecy, and fulfill victims' access to rights and the right to justice. Accountability for state combat secrecy and terrorism and state-sponsored terrorism may be established through the non-binding articles on state responsibility of the United Nations International Law Committee. And we should also obviously keep in mind the relevance of terrorism to crimes against humanity and genocide. So I'll just move forward and just state something that I think would be important. This is just an example. Obviously, there's a delicate balance, so I'd like to stress that it's become apparent that upholding human rights and effective anti-terrorist measures are not exclusive. On the contrary, human rights and the rule of law are essential tools in the effort to combat terrorism. But let's examine, for example, in 2004, a large group of Chechen rebels attacked a secondary school in Russia. I don't know if you recall this moment. Some of you may be too young. The school was located in Beslan, largely Christian North Ossetia, near Chechnya, in the mainly Muslim Northern Caucasus. The majority of the hostages were school-aged children. The rebels demanded the end of the Russian military presence in the Republic of Chechnya. The terrorists attacked the school on the first day of September, which is the first day of school. This was during a ceremony marking the start of the new school year. The terrorists cornered off all the children and teachers into halls and classrooms like cattle, to be slaughtered under armed guards. They mostly held them in the gym, which was rigged with explosives. Children were held at gunpoint to deter any Russian efforts to attack the Chechens. The Chechens made their demands and they refused the emergency services access to the hostages and even denied them water. Eventually, they allowed some medics to retrieve the bodies of those who had been killed during the storming of the school. And for some reason, one of the bombs in the gym exploded, and it is believed that it detonated by accident. The building partially collapsed, and this allowed many children to escape. As they did, the rebels started shooting those children one by one. This led to the Russian special forces being ordered into the school, and a major battle ensued. Over the course of the next few hours, the Russian troops secured the building, killing 31 terrorists and capturing one. The rescuers discovered hundreds of bodies in the ruins of the destroyed school. Approximately 340 students and teachers had been killed, and more than 700 were wounded. The attack on the school was one of the many atrocities that took place during the two Chechen wars. I met the mother and father who lost a child during that terrorist act, and the parents solely prayed for accountability and did not much care about the fundamental rights to stage such acts of terror in the pursuit of noble freedom from tyranny under an aggressive regime such as the Russian Federation. Tyranny does not beget liberty, but chokeholds and shackles the spirit. This terror attack is reminiscent of 9/11 and its aftermath. And it goes without saying that the need has arisen to quantifiably and justifiably place terrorist activities on respective watch lists, much like alerting a neighborhood to the existence of sexual predators who lurk in deep shadows preying for children. We have a right to know where terrorists gather and whether there is a danger posed, so that we can thwart such horrendous terror acts as the Boston bomber. But we must equally protect against the deprivation of liberty and retain the absolute right of freedom for the international norms under international customary law and use cogents. This is very important. And I want to say something else. My grandfather, who, I'll just say this, my grandfather, who was imprisoned under the Stalinist regimes, he spent 10 years in the Gulag camps. With his throat cut, he escaped, and he wanted to fight for democracy in that country. He wanted a free market economy. He was a dissident. And so in cases of dissidency, true cases like that, it's very difficult to label somebody a terrorist. He was a man that wanted change. And here is where we find that delicate balance of whether there's actual dissidency and the right to complain, such as my grandfather did and finally emigrated to the safety of the United States, and those moments when there are actually terror acts that lead to something that happened, whether it's the Boston bomber, 9/11, or the two Chechen wars. Thank you so much.
Thank you very much, Sophia. And yes, when we discuss human rights, we also discuss our personal history. So we really thank you for sharing that with us. Before to start with the proper panel, we will listen to a presentation from a special rapporteur, Professor Meg Satterwhite. She's a professor at NYU School of Law, and she sent a video that we will show. And she's the special rapporteur for the independence of lawyers and judges. Let me stress that this relationship between human rights and counterterrorism has led the United Nations system to create a special rapporteur on the protection of human rights while countering terrorism. And that special rapporteur, Professor Ben Saul, couldn't be with us today because he's traveling towards in Africa. But after the general presentation of Professor Satterwhite, maybe I will take 1 minute to summarize his most recent communication relating to the situation in the UAE.
My name is Margaret Satterwhite, and I'm professor of criminal law at European History School of Law. I'm also the UN Center Rapporteur on the Independence of Lawyers. I'm so happy to be with you in person today, but I'm grateful for this opportunity to speak with you about some issues that fall within my mandate as the UN Special Rapporteur. In particular, I want to highlight the importance of independent judges and the free exercise of the legal profession in ensuring that counterterrorism cases respect fundamental human rights that are enshrined in international law. In states around the world, national security interests are used as a basis for amending, degrading, or abrogating standards set by human rights law and national constitutional law. But international law is clear that the fight against terrorism is no excuse for attacks on fundamental human rights. The right to a fair trial is recognized not only in human rights treaties, but also within international humanitarian law, international criminal law, international counterterrorism conventions, and of course, customary international law. The right encompasses several key interrelated features, including access to lawyers, disclosure of evidence against the accused, adequate time and facilities to prepare a defense, and a fair opportunity to contest the allegations. The right to a fair trial applies whatever charges the accused is faced with, including allegations of terrorism or crimes against national security. Article 14 of the International Covenant on Civil and Political Rights provides that everyone is entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law in the determination of any criminal charge against them. In its general comment number 32, the Human Rights Committee stresses that this guarantee applies to all courts and tribunals, whether specialized, military, or civilian. In the same general comment, the Human Rights Committee examined the types of modified procedures that apply to terrorism offenses in many states and explicitly rejected the contention that these could satisfy the requirements of a fair trial enshrined in Article 14. The committee stated, some countries have resorted to special tribunals or faceless judges composed of anonymous judges, e.g. with measures taken to fight terrorist activities. Such courts, even if they identify the status of such judges has been verified by an independent authority, often suffer not only from the fact that the identity and status of the judges is not made known to the accused persons, but also from irregularities such as exclusion of the public or even the accused or their representatives from the proceedings, restrictions of the right to a lawyer of their own choice, severe restrictions or denial of the right to communicate with their lawyers, particularly when held incommunicado, threats to lawyers, inadequate time for the preparation of the case, or severe restrictions or denial of the right to summon and examine or have examined witnesses, including prohibitions on cross-examining certain categories of witnesses, e.g. police officers responsible for the arrest and interrogation of the defendant. Tribunals with or without faceless judges in circumstances such as these do not satisfy basic standards of a fair trial, and in particular the requirement that the tribunal must be independent and impartial. End of quote. The requirements to ensure a fair trial are clear, but legal norms alone are insufficient to ensure their fulfillment. The daily work of protecting and upholding these fair trial principles is carried out by individuals working within the justice system. Judges and lawyers play a vital role in ensuring that criminal processes, including those concerning allegations of terrorism, remain within the guardrails set by international and domestic law. Judges must uphold the rule of law. They must guarantee that the same laws are applied to all members of society, including individuals accused of terrorist offenses or of otherwise being enemies of the state. In doing so, judges ensure that national security law is not weaponized by governments against political opponents or human rights defenders. Judges also must make certain that laws in their application comply with relevant legal standards, including international human rights law. This duty is especially pressing in relation to counterterrorism measures. In many countries, governments have claimed that existential threats such as terrorism or risks to national security justify suspension or of constitutional rules or individual rights. Judges are tasked with evaluating these claims against binding legal norms. Lawyers fearlessly represent their clients, drawing attention to infringements of law and procedure and demanding their correction. Where appropriate, lawyers also bring specific legal action to vindicate rights that have been contravened. In order to fulfill these functions, justice actors require protection. Judges must be independent and impartial. In particular, they must not be subject to interference from governments, which have political objectives around sensitive issues of national security. And lawyers must be free to represent any clients without fear of facing reprisals or of being associated with their clients' causes, particularly when those clients have been accused of the highest crimes against the state. Counterterrorism and national security cases are of the utmost seriousness. In many jurisdictions, these offenses attract penalties of life imprisonment or even capital punishment. It is thus vitally important that no corners are cut and that all applicable safeguards are extended to individuals facing prosecution for these crimes. Independent judges and free lawyers must be allowed to play their indispensable part in these fair trial guarantees. I extend my thanks to the NYU Center for Global Affairs and the New York City Bar for inviting me to deliver this video message. And I wish you well for this important discussion. Thank you.
Thank you very much to the special rapporteur. And as you may understand from the tone, of course, the tone is one of engagement with states, as what we, when we teach international law, we say the law as it should be. But probably the law is not respected or enforced as it should in situations as the ones that we are looking at. And before to start the panel proper, let me only say that when you have incommunicado detention, so you don't know the whereabouts of individuals that for years have no contact with anyone, neither their family, their lawyers, and so on, we call these enforced disappearance of persons. This is an international crime, qualifies as a crime against humanity. And in fact, in the report that on the 10th of January 2024, a group of special rapporteurs, including Professor Satterwhite, but the first one is Professor Ben Saul from Sydney, who is the rapporteur on counterterrorism human rights. They also refer to the fact that in some cases relating to the United Arab Emirates, there are individuals who for several years are incommunicado, their absence amounting to an enforced disappearance of persons. And they ask the government of the UAE to respond, where are they? Can we know where they are? Can they have access to their family, the lawyers, and so on and so forth? So this is one of the examples that we'll discuss later on in the panel. But I think we have a very distinguished first panelist, certainly the one who has the largest experience in the rule of law among us. And we are honored to have Honorable Lisa Ridgway, senior judge, a council member of the International Law Section and a board member of the Rule of Law Institute of the American Bar Association, a member of the Council of International Affairs, and a founding member of the Independence of Lawyers and Judges Task Force of the New York City Bar, an adjunct professor of law at Cornell University School of Law, and a judge who served in so many important courts, including 25 years of service at the Court of International Trade here in the United States. So, Honorable Ridgway, we are very, very pleased to have you today. You gave us the news about the very important conviction that took place a few, 1 hour ago here in New York City. And as a member of the bench, we are very inspired to have you among us, Honorable.
As a federal judge, I have no political views whatsoever. So I am, I've got a very short period of time and a few points that I want to make. So I'm going to treat several ideas in a fairly cursory fashion, but I should also say first that I am such a huge fan of the UN Special Rapporteur, who is relatively new at her mandate, but is doing some really extraordinary work. And I'm going to spotlight two things relatively quickly. One is she has a pretty expansive view of the mandate, which is what I think today's world requires, candidly. And then secondly, she is phenomenal at communication, but social media in particular. And I'm going to return to both of these themes as I get a little bit further into my presentation. I am going to suggest, though, that if you are on, you know how they say the artist formerly known as Prince, right? So this is the medium formerly known as Twitter, right? She has a very big presence there, and I would encourage you to follow her there. And then she also has, I'm actually not sure if it's quarterly or bi-monthly or whatever, but she has an e-newsletter that she does. I'm speaking now about the UN Special Rapporteur again. And it's pretty easy to find if you go to her webpage on the UN. And I would encourage you just to, you know, sign up for that because it's really terrific. terrific. But when you do programs like this, even if she's not on it, I mean, she will help, blast it out to the world. So it's a great contact to have. I'm actually not going to spend any of my time talking about the facts of the UAE 84 case. I suspect many, if not all of you, already know a great deal about the case, possibly more than I do, but certainly there are others in the room who know much more about it than I do. So, forgive me, but I'm going to skip over that. But one of the key points, and Professor Satterthwaite touched on it, is the issue of the independence of the judiciary, and in particular in the case of the UAE, and in this case in particular, what we see is the use of foreign judges. This has been a massive, long-standing structural, institutional issue in the UAE, but of all of the kinds of cases where it is important, it is critically important in these very sensitive national security cases, the mass trials like the UAE 84. And so what you see, and again, I know that others will speak in greater detail about this, but the presiding judge is actually from Jordan. And this is, for lack of a better word, rented judge. Just huge numbers of, so here's a whole other issue, is just the lack of transparency. We know that the UAE is one of the countries that makes the greatest use of these foreign judges. And by the way, there are some good things in some systems about the use of foreign judges. In the UAE, the system was initially adopted because in 71, with independence, the view was that the Emirates did not have sufficient numbers of experienced lawyers, particularly experienced in certain fields that were important to the judiciary. And so the idea was to, import judges. And our understanding is that it's from Arab countries, but I know that in the commercial courts, for example, they have used judges from, non-Arab countries, or at least have tried to, and it's been very controversial in those judges' home countries. But in any event, so what you basically got is like this rented judge system, Jordanian judge at the helm in this particular case. And, you say, of course, so you're probably going to hear some more about the UN Special Rapporteur on the Independence of Judges and Lawyers 1994 report. So this is now a full decade old, but even then, and not this UN Special Rapporteur, obviously, even then there were questions that were being raised about what's the rationale, at this point. We understand that in 1971, that there was a need for judicial experience, and this was a way of getting it. What is the rationale now? And in particular, what is the rationale for this court? Like, why would you put a foreign judge in charge of your, basically, national security apparatus? It's, the short answer is that this is the system by which the Emirates maintains control of the judiciary. And again, not just this bench, but certainly this bench. And this one is the one that we care about right now because of the sensitivity of this case. So, but again, it's spread throughout. Lack of transparency. We actually don't know just how widespread it is, or who the judges are, or what their terms are. And that's the thing, is that this system allows the Emirates to bring in judges and then to basically dismiss at will judges that, do not meet with their approval, that don't render judgments in accordance with the UAE authorities' wishes, and to extend the terms of those judges who do. So I'm going to stop with that point there, but I'm sure that it's a theme that you will be hearing more about. The second point that I just want to touch on, and again, the UN Special Rapporteur has already set the stage on it, done a magnificent job, is the patently overbroad and the exceedingly vague nature of the anti-terrorism, counterterrorism law, you know, whatever you want to, whatever terminology you want to use. And this is a real challenge because it's really a matter of how the law is applied, less than how it is written. I mean, if you look at the way that these laws are written, you know, some are more egregious than others, but, you know, they're all walking a fine line between civil rights and national security, right? And so the real rub is in how they are applied. And that's just extremely, you know, difficult to address. But basically, in way too many countries, and certainly in the UAE, but in other countries as well, these laws are weaponized to silence dissent and opposition. Again, like I said, this is an issue in countries around the world, including some who are not the usual suspects. Even the US is sometimes on the wrong side of this, at least in my view. Again, as a federal judge, I have no political views whatsoever. You know, like, look at your watch. This is the time my impeachment begins. But the country that I am most familiar with, where I followed the issue most closely, is Turkey. And I'm going to curl your hair here. In Turkey, it is a terrorist offense to represent someone who is accused of terrorism.
Here we go.
And who is accused of terrorism. So it's terrorism to be opposition or dissent, to be anti-Erdogan, basically. So if you are a lawyer and you represent someone who is accused of terrorism because they express views that are contrary to the views of the Erdogan regime, then you are yourself charged with terrorism. And I'm not exaggerating here. Twice in the last couple of years, 2022 and 2023, I was actually in Turkey to observe trials and then to follow up, to visit lawyers in prison, mass trial of 22 lawyers for exactly this. And, you know, I told you I was going to really scare you. If that's not enough to scare you, now Turkey is prosecuting the lawyers who defended the 22 lawyers who were being tried in the mass trial for do you see? So we're like third generation now. You know, it would be comical, except that it's not, right? And then just in the last 24 hours, not in the last 2 hours,
Okay,
like
24.
the verdict in the President Trump case, but in the last 24 hours, we've had the verdict in the Hong Kong 47 trial, which I'm sure a lot of you have followed. And there, a lot of the 47 pled guilty under a variety of different circumstances and for a variety of reasons. But 14 of them actually went to trial and have now been found guilty. And all of them are facing life in prison, not death, which is the case with the UAE 84, but life in prison, which as a practical matter, right? And just one other point I want to make before I move on from this topic is that there are like 3 or 4 different layers of impact in terms of, you know, this representation issue. So, you know, most immediately you have the impact on the lawyer who is accused of terrorism, right? So, I mean, that's the obvious one. But there's also a very direct chilling effect on other lawyers. And You know, I'm so proud of our profession. I like to think that this would be me. I have my doubts. But, you know, for some lawyers, it just makes them double down. Right? They become that much more courageous, that much more determined, but also that much bigger a target, right? For the Erdogan, you know, regime, which, you know, chooses its targets very carefully. And I'm picking on Turkey, but Turkey is by no means the only country. It's just the one that I know best. The one that is perfected the autocrat's playbook. That's the term that everybody uses now. Anyway, so, you know, as a result, we now have growing reluctance of lawyers to accept these, you know, so-called sensitive cases. So, you know, the pool of lawyers willing to do this work is shrinking. And of course, that's what the regimes are counting on. Then third impact, and, you know, most people don't think this far down, is just the impact on the dissidents who now know that they are going to have difficulty or find it impossible to get representation, and the chilling effect that it has on them. And then ultimately, and this is really important because this is a right of the public under all of those, you know, international treaties and conventions that the special rapporteur was talking about, you know, the right of the public to, you know, a fair trial or right of access to lawyers and so forth. And so, you know, as the pool of lawyers as a whole shrinks, it directly impacts the public completely without regard to terrorism. Anyway, and I just want to, you know, throw out, it's not my idea, but it's one that I've glommed onto. FATF, and I can never remember, FATF, I can never remember what the acronym stands for. I know someone else will be able to fill that in, but in any event, it's, you know, like the international body that is looking at how to regulate financial matters to control terrorism. I'm getting some knowing nods, so maybe I didn't completely blow that. But anyway, you know, FATF has long been walking this fine line. They totally get the encroachment on civil rights, the potential, and the way that the laws are being weaponized in some countries. And so they're keenly aware of this. But I'm just kind of thinking that we are now at the place where we've got to take a big step back and fundamentally rethink how to approach this, because it's just not working in too many countries. And it's in fact empowering the very people that we don't want empowered. Third point that I wanted to raise, but I'm not going to go into it in any detail at all, is just the basic fair trial issues. Like we started out with the independence of judges and lawyers, but you've also got to think of it in terms of the fundamental fair trial issues, you know, access to lawyers, as I'm sure someone else will talk about. You know, there's been extensive use of solitary confinement in this case, which is you know, tantamount, if not equivalent to torture. Anyway, very, very long list of fair trial issues that are raised in addition to the judicial independence issues. But, you know, candidly, it's like the fair trial issues don't even matter if you don't have an independent judiciary. So that's why I kind of lead with that one. And that's why I suspect that's the one in the headline of this program, is because we don't even get to the fair trial issues unless and until we get past judicial independence. Another very serious long-standing problem has been the absence of media scrutiny. And again, this is inextricably intertwined with the other issues. You know, journalists who dare to speak the truth have long been stamped out. They are themselves labeled and tried as terrorists, and it's, you know, all of the same issues that we were talking about in terms of the chilling effect. So you go after a couple of them, high profile, and, you know, the message is sent and received to the journalists and the media everywhere. But again, certainly within the country, but even outside the country, this trial and this issue writ large, however you want to label the issue, judicial independence, fair trial, whatever, is not getting nearly the publicity that it would because of both inside and outside the country, because of the restrictions on the media. And then there are numerous other, again, I should contextualize this, but time prevents me from doing so, but numerous other human rights issues. We shouldn't pretend like this is the only one. And you're going to understand particularly why in just a second. But women's rights, gay rights. Some of you probably know about the kafala system, which is sort of a system of labor, almost indentured labor, vast numbers of workers, vast numbers. Again, lack of transparency. We don't know exactly how many, but vast numbers of workers are brought under sort of a system of sponsorship to the UAE, but they are then bound to their employers. And again, it's KAFALA, you should read up on it if you're not already familiar with it. And they're just massive human rights abuses against these workers. So, on top of, my point is just that on top of the human rights issues that we're talking about here today, there's just a multiplicity of other human rights issues that we should be talking about when we talk about these. And then, as you heard the UN Special Rapporteur talk about, although I think principally in terms of the UN basic principles on the independence of the judiciary and the UN basic principles on the role of lawyers. And by the way, there's also a set of principles on prosecutors that you don't hear nearly as much about, but it's very important because, as you know, in much of the world, certainly in the civil law world, prosecutors play a very different role than they do here. And so even here it's important, but it's especially important to be aware about that. So even though I think of it in terms of conceive of this in terms of the UN basic principles, the UAE is actually a party to a whole bunch of international instruments, treaties, and so forth, the ICCPR, I mean, the list goes on, Convention Against Torture. I also want to touch on something that Chris Piak said, I'm hurrying,
Yes.
That Chris Piak said, which is about the importance of advocating for the independence, safety, and security of judges, prosecutors, and lawyers. And I would also add journalists in there as well, because I really do think that journalists are inextricably intertwined. We need them, they need us. They need us to protect their right to do what they do. We need them to, report on whether, you get the drift of it. But anyway, I would throw them in together with judges, prosecutors, and lawyers. But in the defense industry, there's a term called force multiplier. And judges, lawyers, prosecutors, journalists are force multipliers, right? You just hear the term and you know what it means, right? There are basically, I can't protect everybody's rights in Turkey, but I can do my damnedest to protect the rights of the judges and the lawyers and try to protect their right to protect the rights of their, I would say countrymen, but that's not politically correct. They're country people. Anyway, so that's the reason for the special focus. And I would urge all of us to bear that in mind and to drive that message home when we talk to, human rights bodies. The last point I just want to touch on is the fact that the UAE is actually massively sensitive to its standing or its image in the international community. And that works in our favor as champions of human rights. There are, the truth is, I believe all countries are sensitive to some degree, even those that pretend like they're not. But the UAE spends vast sums of money cultivating this image around the world that of all of the Arab countries, of all of the Middle Eastern countries, that it is the most, that it's the safest, that it's the friendliest, that it is the most, for lack of a better word, pro-Western, you know, in its values and its approach to life and all that. And the fact that they spend so much money, that they invest so much effort in this, tells us that they care. And it makes it obligatory for us to exploit that, for us to look for ways to get the word out, because as we've discussed, we can't count on their media to do it from inside the country because they simply are not able to do it. So, you know, I think that the media outside the UAE has an obligation, but I think all of us around this table have an obligation. One of my favorite causes is sports washing. And that's an area where UAE in particular has invested a lot of time and money. And that is, again, another opening. So, you know, just look for opportunities related to sports to get that message out, whether it's op-eds or letters or public statements or whatever, and say, hey, you know, they're doing this, but oh, by the way, they are sports washing their human rights record. The Abu Dhabi United Group in particular is owned by a member of the Abu Dhabi royal family, who's also a VP of the UAE as a whole. And that entity has a majority stake in the City Football Group, which controls, the biggest one is Manchester City, okay? So, but I'm really serious here. I mean, that matters a lot elsewhere around the world. I'm a Formula One fan, by the way. They've also really exploited that. I kind of look with shame. But football is like a really biggie. And New York City, they own the New York City Club.
Oh, okay.
Why did we not know that? Why have we not spoken out on that? And I would just suggest to you that this is a great opportunity for the law school to partner up with some friendly folks over in the business school and talk about targets and message and timing. Like, you know, we're supposed to be really great communicators. They're supposed to be really great communicators. So, you know, I would suggest that that's something that we could do. So, you know, just in terms of a call to action, I mean, I would ask the UN Special Rapporteur, and I will, we're working on a project together, ask her to keep this case and this cause high profile, you know, for the next however long we have. But, you know, but after that, I mean, the problems are not going to go away. The issues are not going to go away. And the UN Human Rights Council's next session is coming in Geneva, is coming up right away. I'm also going to ask her to extend an invitation to the UAE, to ask her to extend an invitation, to ask her to suggest that they extend an invitation to her. That's what I'm trying to say, because she will only go to a country upon invitation. But it's now been a decade since the 2014 mission and the 2014 report. So she can put a lot of pressure to bear just by asking. They probably won't take her up on it, but who knows? For the rest of us, today's program is necessary. So thank you, but not sufficient. We must do more. And I've suggested some of the things, but, you know, letters, you know, to our own State Department, to the White House. Why has the State Department not made any statement on this case? Nothing. Silence. Crickets. Nothing. You know, the US ambassador to the UN, the US ambassador to the UAE, UAE's ambassadors to the UN and to the United States. And then I was speaking with you, I think, anyway, beforehand too, about, you know, not only using the mechanism of the periodic review, the universal periodic review process, but even more immediately, every year, as we probably already know, the US State Department puts out annual country reports, that's what they're called informally, on human rights. And it's less well known that they actually accept input. And so, you know, along about October, November, find out who the relevant person is for the UAE at the State Department, and, you know, write a really powerful piece and send it to them as input for their report. Thank you for your indulgence.
Thank you very much, Lisa. And I must also thank the American Society of International Law, because without their executive director, we would not be here. And so we are a larger community. I think the Center for Global Affairs also can be a sort of a, our students can take action together with students from other faculties. We have a lot of representation here. Some of our alumni, we have many alumni, they work with the State Department. So let's see what comes out of this conversation. Now, those who produce the reports are actually the NGOs. So I'm very, very proud to have here with us the Deputy Director of the Middle East and North Africa, otherwise known as MENA, I don't know, program of Human Rights Watch, undoubtedly the most prominent, at least in the media, international human rights organization. We have with us Michael Page, and we look forward to hear from you. Michael.
Thank you so much, everyone, for joining. I'll probably swivel because I'm in the middle of the room. My name is Michael Page. I'm the Deputy Director of the Middle East Division. I work on mostly our Gulf countries. I want to thank you. I want to give thanks to NYU, because honestly, it's an incredibly timely event. We're making references to it, but there is the second largest mass trial that is going on that is charging the most prominent dissidents that were made in UAE with honestly likely years or decades in prison at minimum. It is a mass trial where there have already been serious allegations of abuse, including torture, due process violations, and it's something where we expect this verdict to happen in July 10th, and that analysts have thought that we've talked to that they will all be found guilty and they will likely face very serious time, maybe life in prison. And so it's essential, I think, as you've hinted, pressure needs to happen now on the UAE, not just from diplomatic allies like the US, the UK, to pressure to over their immediate release of those who are in prison, but also criticize the trial on its processes and also go to the hearing sessions of the trial that remain. And so I think we're at a really critical juncture. And I think, you know, just to echo Honorable Ridgway, really many of my notes and like key points, because it was really great. But I think, you know, all of these questions are around broad CT laws, lack of an independent judiciary. That is all absolutely true in the UAE. And there's a lot of challenges in terms of doing advocacy with a petro-autocracy, with essentially a country that has an incredible amount of money and then finesse, savvy, and cynicism to deploy that well to essentially silence dissent. So I want to keep it brief because I'm also excited to hear from others and hopefully have a discussion. I want to talk about three areas. I just want to give a very brief overview of the trial. I'm sure some of you really know what's going on, know it well, and I just want to sketch like a very brief outline of it. I want to then kind of zoom out. It's been referenced, but the broader repressive legal infrastructure in the UAE is also atrocious, and it's something that is a major problem for anyone who is essentially, there really is no civil society space post 2012 and 2013 in the UAE. And that's an incredible challenge that people who have spoken up face. And then third, I guess I want to, you know, dig into a little bit more of these challenges and what are some potential solutions. It's not all negative. And, you know, as working in a human rights organization whose, you know, goal is to expose abuses, to document abuses, expose them publicly and seek change, it should hopefully come up with some solutions. So that's, I guess, part of the discussion. So what are we talking about with this mass trial? So just to say that in December 2023, while the UAE was hosting COP28, the premier climate conference, 84 defendants at least were essentially charged with, and I'm just gonna read it, establishing a clandestine organization or committing violence and terrorism, right? And many of these individuals had actually already previously been charged in a 2013 mass trial. And so when we talk about why, it's likely terrorism charges that they're facing, in particular the 2014 counterterrorism law, I mean, this question is, who are these people? These are people like Ahmed Mansour, who is a prominent human rights defender, who also happens to be on our MENA advisory committee, and was like dedicated himself to human rights defense. He's been spied on, he's now jailed, now he's facing a lifetime, in prison, if not worse. We have academics, for instance, Nasser bin Faith, who worked at the Sorbonne's Abu Dhabi branch. We have business people such as Khalid Rumaisi, a guy who visited Jordan briefly, thinking he'd be safe, was arrested, disappeared, and immediately transferred and extradited to the UAE. Just kind of shows like UAE's ability, I think they call it transnational repression. So that ability to project power and influence and literally arrest people who are outside the country's borders. And so these are the people that are on trial now. And it's a trial that's been marred by all the protections that have been mentioned earlier by initial panelists. Essentially, none of those protections are applying to the people who are in this mass trial. And I think I guess we can start with the judge. I don't want to skip over, but it was referenced the 2014 report in terms of the UN Special Rapporteur. Just to read out one quote is that the UN Special Rapporteur on Independence of Judges said in 2014, UAE's judicial system remains under de facto control of the executive branch of government, and that remains true today. So essentially, if we take framing from the previous speaker, all these other issues of due process and fair trial violations, there's a larger problem of the executive branch, an autocratic monarchy, essentially is the ultimate decider when it comes to all significant judicial decisions. Some of the abuses that people are facing, people are facing solitary confinement. Defendants, sources have reported that some people have been beaten in prison. Access to lawyers is incredibly difficult, right? So not only is there difficulty in accessing lawyers, from what we found, can't even share what the charges are or details about the case to their defendants. So it's kind of, in our view, it's a mockery, right? Kind of what a process should be. And I think there's a question of it's kind of one of these broader questions of why does a country that doesn't believe or a judicial system or an executive branch that doesn't believe in these processes, why do they go through the trouble of doing it in the first place? Really, it's something that we can kind of chat about and kind of think through. But all to say is that all of these restrictions are incredibly difficult. And the kind of worst part is many of these people have already been on trial. So there was a previous mass trial in 2013. Essentially, it was a response to the Arab Spring, in which there was this crackdown on repression, and UAE authorities decided we are not going to have any type of civic mobilization in this country. That is not going to happen. So there was a crackdown, what was known as the UAE 94. Essentially, a number of activists, former judges, lawyers, some who worked for the government, were arrested. 69 of those individuals were ultimately convicted. Many of them have already served out their sentences, but now they're going through essentially double jeopardy and facing charges again. Only this time what's happening is that it's going from penal code violations to what seems to be charges of terrorism. And so then let's talk, just to zoom out, is if this is the context of this mass trial itself, right? Why I'm so grateful that this event is happening, because there's been just a shocking lack of commentary, not just from the US and the UK, but international media. It's just silence and apathy. And I think there's reasons for it about how the UAE has created carrots and sticks for influential actors, but it's something that's a problem that is a difficult one to solve. So if that's the trial, what is the kind of larger context of the legal situation? And I think the issue is that as the years have moved on, since essentially the Arab Spring, there have been more and more repressive laws piled on to already existing problematic laws. So I just want to give a few examples. I don't want to read out, much, but many others have written about it, as you referenced on the UN Special Rapporteur's report. It's a great report to read through, and the detail is excellent. But just to name like a few, so in 2014, the UAE published a counterterrorism law. It's called the Federal Law Number 7. And I looked up what Human Rights Watch, my former boss, had quoted at the time. She described the law, the fact as in the UAE now, it's now a case of you're with us or you're a terrorist. And so that framing, I think, has proven quite fruitful for governments that find a more efficient way to essentially shut up diplomats and give a justification for, particularly in this case, Western allies, as well as other countries that want an excuse and justification not to criticize in the first place. And so, what are these types of articles that are in these laws? So just to give one example is you can be sentenced up to 15 years according to Article 15 of this counterterrorism law, simply for publicly declaring animosity or lack of allegiance to the state or the government. So this doesn't in any way resemble what we think or what it should be a narrowly bound kind of explanation of terrorism, which, even though there's no international definition, should really be linked to violence. It should be linking to targeting civilians. It should be very closely correlated with kind of core human rights abuses, whether they're in the context of international human rights law or international humanitarian law. And also, now that these laws have also empowered even more officials who are independent in the first place. So public prosecutors, for instance, are now empowered from this counterterrorism law to order travel bans or surveillance on anyone who is suspected of terrorism-related activities. So that just the broad discretion without any type of independence is a huge double whammy for, essentially allowing civil space. Another, and be super brief, but it's relevant to, again, someone that Human Rights Watch knows as a prominent dissident, and we worked with closely, Ahmed Mansour, the cyber crimes law in 2021. He essentially faced, one of the charges he faced was up to 15 years for anyone using the internet to provide information not authorized for publishing, liable to harm state interests or damage its reputation. That's called journalism. That's called basic activism, right? And so that reality is facing the dissidents that want, and so the judge talked about these cascading effects, second or third order effects. It's very hard to see how someone would conceivably want to be a dissident unless they immediately wanted to go to prison or outside, given that this is the type of law. I mean, then one more to read is, Article 1 of the cyber crimes law is unlawful content that includes content published that harms the state national security or decreases public confidence in the state's actions or institutions. I mean, look, I'm not trying to be facetious, but if we applied this law in a place like New York City and use the UAE state's interpretation of how to apply it, like most of the New York City residents would either be facing charges or in jail, right? And that's the kind of reality of the UAE kind of dystopia. So then the challenge is what do we do with this? Like, I think part of the problem is that we have a sophisticated actor in the UAE that has an incredible amount of wealth. And it's where I link, it's kind of like not looking, it's easy to go off into a tangent, but I think it's notable that they are a petro-autocracy, that it is wealth that is public wealth, that is only decided by small individuals like private elites, and that all of this wealth is essentially killing the planet, as well as often harming you mentioned migrant workers, often harming the people who are most closely building all of the projects are, on the extractive industries. They're the ones who are facing extreme heat. They're the ones who are facing air pollution. And so it is something to note, and where I see there's a future intersection between human rights and kind of climate advocacy is really trying to target and make disdainful and make a public reputational harm for institutions that partner with petro-autocracies, given its just deleterious effects for our entire future. Okay, so the UAE, I think the challenge is that they have taken that wealth and deployed it as a weapon to invest in essentially any cultural, political, academic brand. And that, what is that, did everything from the Guggenheim to Sorbonne, the Louvre, NYU has a campus on Abu Dhabi. And the point here isn't to say that, Emirati students, Qatari students, Saudi students, they don't deserve cultural access, academic access. They do. I think the issue is not that they're there, right? The issue is that what often happens is that there creates an incentive structure for the most senior people in those institutions to remain silent. Because now you can always make the justification of like, we can buy more paintings and we can give more scholarships and whatever. You can always make an argument because these are, I think the phrase is revenue centers. They're usually like revenue generating things that they're offered on very generous terms. And that's a problem because that's not just, civic and academic and cultural institutions, but, it was referenced, why are US officials silent? That same process. I mean, something like the Washington Post has had great reporting on hiring, the UAE hiring hundreds of very senior military officials who now essentially do the UAE's bidding. They've hired former intelligence operatives that do the hacking, including one of the people in jail, Ahmed Mansour, who was hacked with Pegasus software, and then attacks that the UAE has used for other kind of activists and state officials, etc. So what do we do? What do we do about it? I would guess I think there's a few things. One that moves outside my expertise, but I'd be grateful to hear more on it. I think the concepts of counterterrorism in the Middle East that's been applied by states has been incredibly harmful. What terrorism means now in terms of how states deploy it is essentially anyone we don't like. I'll just give one example. Saudi Arabia, there was a woman named Salma Shahab. She was a UK resident, PhD student. She was essentially charged with terrorism for tweeting, right? She was in prison for 34 years. So of course, civilian protection, there have been, militant groups that have used arms and horrific attacks against civilians. But the point is that how they're actually deployed, how counterterrorism tools are actually used is pretty much a battering ram against civil society and individual dissidents that are peaceful in nature. And I think that's the last point is just to know that what we can do. I think trying to pressure institutions culturally and academically and raising the stakes on the reputational damage that they face is really key. And so that's internal advocacy, in institutions. And of course, we've seen this in other contexts, right? I mean, it's on the context of Israel-Palestine and for Palestine rights. This has been an issue that's been on campuses and a framing of divestment. I think for each tool, we should be policy tool neutral, but it's really important to pressure these stakeholders to, at the very least, speak out on these rights at the most senior level. Because if you're not, then you're essentially whitewashing these regimes, and that's the big problem. That's the real harm that's being done. Because then this whitewashing makes it so much more difficult to essentially apply fundamental international human rights law. I've gone all over my time, but I really appreciate the ability.
Thank you very much. Thank you very much, Michael. I think the perspective of Human Rights Watch is unique because you don't accept funding from government. You're absolutely independent. You really play your role as an agent for the international community of human rights activists and defenders. So we're really grateful for that. Of course, the main problem here is counterterrorism is based on international agreements relating to counterterrorism. There is a global consensus. When you read the G20 communiques, you study global affairs here, and the G20 agree on essentially two things. Thanks God, they agree on addressing the climate emergency, maybe because it's self-survival. The planet needs to continue to exist, correct? And the second, the terrorists, the evil. Let's destroy them, let's eliminate them, let's eradicate them. Problem is, most of them, they are not those labeled with that name. So what do we do with that? Is it fair that we continue to use international law to pursue what normally dictatorship used to do? And we disagree with them, but at least they have the clarity to say, here we are, we proceed with this doctrine. It's called Bahatism, it's called fascism, it's called whatever it's called, but it doesn't. That's why maybe this is the problem with the trial. The trial wants to look like as if there is a trial, whereby maybe there is not. But hopefully there is, because probably the interests relating to the international community standing of one country may supersede the short-term vision of being super protective of a power that is not really challenged, by the way, by 100, because the initial case was about 134 protesters participating in the Arab Spring and co-signing a letter of intellectuals, academics, jurists, and so on to the emir. So, you know, how can 134 persons subvert the national order? So it's very complicated, but I think we'll go there. So now we have two non-lawyers finally in the room that will speak. And the first one to do so came all from Montreal, very far from here, from another country. My friend Kyle Matthews, who is the executive director of the Montreal Institute for Genocide and Human Rights Studies at Concordia University. Kyle is really a force of nature. He organized in Montreal the International Security Summit in October. He's going to organize another one this year. And he honored me to be part of the advisory council of his organization under the leadership of the individual, the only individual who tried to stop the Rwandan genocide, General Romeo Dallaire, who is the chair of your board. So Kyle, thank you for being with us. And I know you will have a broader perspective as the next speaker will, but then the final speaker will come back very much on the UAE situation.
Thank you for the invitation. Great to be here, everyone. I'm going to try to be succinct, but shorter than everyone else, because I know we're running out of time. So I started my career with the United Nations High Commission for Refugees in the Southern Caucasus. So I'm glad my colleague here brought up North Ossetia. I worked close in Pankisi Valley, where there were Chechen refugees. And in 2003, 2005, we began to see a lot of foreign fighters. These are not Georgian nationals. They weren't Chechen nationals. They're mostly people coming from the Middle East, going to fight in Russia, to fight in Chechnya. So that was my first exposure to what we call foreign fighters, violent extremism, terrorism, what maybe call that now. Going forward to my career, I began to look at a lot more identity-based issues. And I began to see, starting in the 2000s or late 2000s, a rise in non-state actors and non-state actor violence. So while many people have talked about looking at authoritarian regimes that are misusing terrorism laws, looking at how overreaction by states to deal with terrorism can impact human rights, there's another side to the story. The other side is that we've seen and we've witnessed non-state actors commit some of the most horrible, violent acts across the planet in the last 50 years. So who here knows about human security? Human security, the concept that my government, Canada, tried to push through in the 90s after the failure of Rwandan genocide. So they helped create something called the Responsibility to Protect, which is a notion to prevent mass atrocity crimes. Then we saw the creation of the International Criminal Court that has a responsibility to prosecute for these 4 specific mass atrocity crimes: genocide, ethnic cleansing, crime against humanity, and war crimes. This is the formation of 2 key, one institution and a norm that was set up and still is surviving today. I'd say R2P is not doing that well. But what we began to see, and I really say this is really with the Arab Spring. As the Arab Spring took off, we saw chaos emerging in Libya. We saw a UN Security Council vote to stop Gaddafi from attacking a city. NATO helped bomb forces. We began to see that site unravel, and a bunch of Tuaregs that supported Gaddafi fled into Mali and the Sahel. At the same time, we began to see authoritarian Syria push back against children or teenagers that were protesting wanting democracy, saw that turn into a massive civil war, nothing civil about it. And actually, it was not just a civil war, there were a lot of external actors engaging in that war. But what we saw really in Syria, began to see a rise of non-state actors. This case was ISIS, former members of Al-Qaeda, that basically took control of a big chunk of Syria, took control of a big chunk of Iraq, an area larger than the country of Belgium, starting to commit mass atrocity crimes, genocide of Yazidis. We saw the Yazidis that were targeted, all men and boys were killed by this group. Women were taken as sexual slaves. Those are all actions of under the genocide convention. They committed genocide against it. We saw violent attacks against sexual minorities, against secular Muslims, against Shia Muslims. This was a security threat and a human rights threat wrapped into one. And because of that, we saw a strong response. But we began to see from that a notion that terrorism can actually be quite dangerous. It's not just the old days of the radical left or the German neo-Marx party blowing up a mailbox here and there. Began to see actual commission of atrocity crime. So I think knowing that and understanding that can help us also understand that we have to do something to counter some of these groups. So anyone who's interested in terrorism, if you don't, I would suggest if you're a lawyer, a judge, a student, a practitioner, the Institute for Economics and Peace produces something called the Global Terrorism Index. It's an annual report. It highlights every terrorist attack, number of casualties per country, who did it, or who they don't know who did it, changing patterns, and it is a phenomenal source. And I say this because I've had the pleasure to work with them to do a launch of the report every year at the Canadian Parliament and to brief the RCMP, the Canadian Border Security Service, and other security agencies as well as Global Affairs Canada to show what's happening. And I tell you, the report that just came out a month ago shows that 95% of the casualties on the planet are carried out by 4 groups: ISIS, Al-Qaeda and their affiliates, Boko Haram, and Al-Shabaab. The Taliban is not involved anymore, they form a country, they're not considered terrorists because they control the government. But if you look at the statistics, those are the main dangers in 2024. It could shift, it could change. We've seen multiple waves of terrorism. With left-wing terrorism, we might see a rise of far right. We're starting to see it a little bit, not as much as the media reports, but these are the main challenges. We're seeing this actually really have an impact on the large swath of the world. Not the US, not Canada, not really Western countries, but predominantly we're seeing more in the Sahel, Sub-Saharan Africa, Mozambique. And I've been telling you, these terrorist actions, it's not just killing people. We're seeing systemic attacks on schools. There's now an NGO that I think Human Rights Watch helped set it up, Education Under Attack. We're seeing attacks on heritage sites. One part of destroying someone's identity is by attacking the heritage sites and historical monuments. We're seeing mass displacement of people. We're talking like millions of people that are being added on to the UNHCR refugee list that are caused by this violence. We're seeing food security. So these are some major issues that deal with human rights, a whole set of human rights. So we have to kind of understand that as well. But there is overreach, and we have to be careful of that. I'll just say one thing about overreach. I think we have to, human rights activists, lawyers, NGOs, judges, you name it, have to stay committed. If we're going to focus on terrorism, we have to look at it as it's the intention to commit a violent act for political or ideological reasons. To commit a violent act. So we can't allow authoritarian states or even some democracies to start using these laws to target dissidents, political opposition, journalists, human rights activists, or others. That's a danger point. We're seeing that. There were cases mentioned of Turkey. I believe I wrote an op-ed about 8 years ago. I think there were 2 Turkish journalists that wrote a report on the Turkish intelligence agency giving weapons to ISIS in Syria. And those 2 journalists were charged under terrorism charges. I think they're still in jail. We see Russia increasingly using also the term violent extremism or extremism writ large to target LGBT communities, Jehovah's Witnesses, anyone who's a political opposition. We're beginning to see the same thing in China. The persecution of the Uyghurs, 1 million to 2 million Uyghur Muslims are in basically concentration camps undergoing through a cultural genocide, if not a genocide. And that's being done under the argument that there's a risk of extremism and terrorism, and therefore they must completely erase or turn them into Han Chinese in order to erase those cultural differences. So I just wanted to say that the link between terrorism and mass terrorist crimes does exist. It does exist. We need to focus on that. But we also must push back against authoritarian states that are misusing it. Thank you very much.
Thank you very much, Kyle. But maybe for the second round, since Honorable Ridgway referred to sport washing, what happens in Qatar hosted the FIFA World Cup, the greatest public event in the world. What happens if the International Criminal Court confirms the request for an arrest warrant to the big boss, the ideological boss of Hamas, Dr. Haniyeh, who is a very wealthy man and lived peacefully in the state of Qatar? What will Qatar do? What other states will do? And because, of course, he carries that ideology that led to the 7 October attacks in Israel. The next speaker is a colleague, and I was so lucky to meet her thanks to this event, Dr. Yumo Ayandele. She's a visiting assistant professor of practice at NYU CGA, where she teaches a number of very important courses. The only thing I know is that all students love your courses. And above all, she's a member of the UN Counterterrorism Executive Directorate, TED, Global Research Network. So having worked in Nigeria, I think she will have a lot to tell us. But let me say something here on Somalia, because I agreed on everything you said, Kyle, but not on one thing. Al-Shabaab. Open your ears. The biggest killing that took place a month ago south of Somaliland was attributed to Al-Shabaab. More than 700 civilians slaughtered. It was orchestrated and done by the government of Somaliland, according to the testimonies of hundreds of survivors. 5,000 people survived that attack. The government of Somalia regularly attributes to Al-Shabaab each act of violence that the militias of the prime minister are committing against the supporters of the president, and the militias of the president are committing against the supporter of the prime minister. And we can go on and on and on. And every 1,000 people who die in Somalia attributed to Al-Shabaab, I submit to your attention, maybe only 100 or less are really the result of this organization that has been bombed by drones and by attacks from all sides. And I don't know how is it so strong that it's still able to destabilize an entire country that is as big as Texas. So I think, you know, we need to debunk and deconstruct. I look forward to the next report of Human Rights Watch on Somalia. Please do so if you need. I have, together with my friend Rodney Dixon here, we are very close with the defense lawyer that represent the victims of the massacre I cited, Mr. Galliani in Italy. So I think it's very important that we understand what the victims tell us. And the victims know what they have seen, and they have not seen Al-Shabaab. So, you know, okay, somebody's noting. I'm very happy in here in the class, but I sometimes have a lot of difficulty. But
I was citing the Global Terrorism Index.
Perfect. So, Yumo, I'm very, very delighted that you are here, and please take the floor.
Thank you very much for the invitation, and I will be piggybacking up Kyle and giving an overview using the Lake Chad Basin region and Boko Haram and what the Nigerian government has been doing in that region. And I actually want to shed a positive light on counterterrorism and why the respect of human rights sometimes actually leads to effective strategies and policies, and what we can actually learn from Africa when we are thinking about counterterrorism and the war on terror. I'm going to put that in quotes. And I want to start off by talking about the Regional Joint Task Force, the MNJTF. And the reason why I want to talk about the MNJTF is because the Regional Task Force is mandated to stop the regional expansion of Boko Haram. We all know that Boko Haram and groups such as ISIS or Al-Qaeda affiliated groups do not respect borders. So when it comes to counterterrorism, you can't afford to, have a national security strategy without necessarily having your neighbors also buying into that strategy. So I want to talk about the MNJTF. When it was established, we saw a lot of violations of human rights. We saw lots of arrests, detention, sexual violence, allegations against women. And then, the Nigerian government and a lot of these regional partners took a step back, and in 2020, actually built the Civil Military Cooperative Cell. And the Civil Military Cooperative Cell has been very, very pivotal when it comes to fostering this crucial collaboration that is needed between security forces, civilian and humanitarian agencies, and local communities. And the main focus is actually compliance of international human rights norms and how that can affect counterterrorism strategies. and it's been relatively successful. I do look at the, GTI, and when you compare what's going on in the Lake Chad Basin region to the Central Sahel or Horn of Africa, we actually see that, when it comes to fatalities, attacks, it's gone down in the last 15 years in the Lake Chad Basin region. So something is working. And that's kind of what I want to point out in my brief comments. I'm going to take like 5 to 10 minutes and then hopefully open it up for discussions. So when it comes to this crucial collaboration that I had mentioned, we are seeing a lot of community dialogues. And this implementation of several training initiatives and programs that I had said focus on protecting civilians, like focus on addressing gender-based violence and complying with international human rights laws, as well as international humanitarian law. And I would say that these training programs have really enhanced the attitudes and the skills of this regional task force, especially when it comes to winning the hearts and minds of local civilians. When we're thinking about addressing violent extremism for countries who have been dealing with it for over a decade, that's one of the most important things that a government can do, especially when it comes to rebuilding the legitimacy that it has lost. And the data kind of supports that. I do not use GTI, I use ACLED. Shameless plug, ACLED is the Armed Conflict Location and Event Data Project. For those who are interested in conflict data, we actually do real-time data tracking for all the countries in the world when it comes to political violence. And when we look at what the MNJTF is doing with regards to violence targeting civilians, since they implemented this program in 2020, we've only recorded 2 instances, compared to the many instances in other contributing countries such as Nigeria, Chad, Niger, and Cameroon. So something is definitely working when it comes to counterterrorism and the respect of human rights. And why is this important? I would say it's very instrumental, one, in fostering trust building when it comes to security forces within these areas. And it's been very, very important for communities to actually want to provide that local intelligence that is needed. So you had mentioned identity. And, when it comes to these violent extremist groups, they've been able to use identity to actually mobilize and recruit foot soldiers. So being also able, from the government perspective, to use that identity while also respecting human rights has been very, very crucial in the fight against, I would say, Boko Haram in the Lake Chad Basin region. And when it comes to counterterrorism and human rights, I would say that these cooperative practices are moving beyond military-centric strategies that we see when it comes to the war on terror. So when we think about even saying the war on terror, basically signals that it needs to be militaristic. So we're trying to take a step back and say, when we think about war, when we think about addressing violent extremism, maybe we need to think about a bottom-up approach, right? When it comes to the respect of human rights. And we've seen, as I said, a relative success with the recapturing of territory, with the reduction of attacks, with, a lot of associates surrendering to the Nigerian government. So we've seen over 100,000, for example, combatants lay down their arms and say, we are ready to be reintegrated into society. But now what's the next step when it comes to counterterrorism? I would say it's transitional justice. That's the thing that's missing. And what does that look like? It's going to be very local specific. It's not a one size fit all. And I would say it should focus on community-based truth telling, justice, forgiveness, and reconciliation measures. And not to ruffle any feathers, but I would say when it comes to the independence of judges, it needs to also move away from just being formal. When it comes to these local communities, we have a lot of community leaders who already do this. So how can we join the formal and the informal when we think about transitional justice? I feel like that's the one thing that is missing from this conversation that we've had tonight. Because we've only focused on what lawyers can do, what judges can do in the formal sector, forgetting that when it comes to these local communities that are affected, the people that they are going to go to are the community leaders, not necessarily the lawyers in the formal sector. So how can we bring them in when we're thinking about counterterrorism? How can we bring them in when we're thinking about human rights law? And how can we bring them in when we're trying to reshape the independence of judges. This might just be the step that we need in reframing what we say is the war on terror. So I will stop there.
Thank you very much, Humo. And I think there is really a pattern there in the sense that both of you identified identity-based violence, violent extremism underpinning authentic terrorism vis-a-vis what the other speakers have described as, false accusations of terrorism and so false definitions, as well as the necessity to have violent acts defined as terrorism and not acts that are contravening the status quo or the majority opinion or the power base. And maybe for the second round, we could engage on maybe is relabeling this an exercise worth of consideration, in the sense that why should we continue to call it terrorism? Can we call it with all these other names that you eloquently put forward? And certainly, let me tell you one thing, Humo. I've met a lot of Nigerian lawyers, less political scientists as good as you, but such lawyers are really good, really talented. And so I think transitional justice stands on its own feet when also there is the alternative of the formal avenue. Then it becomes much more credible, and it becomes sort of not the only resort, but the one that can bring about reconciliation and long-lasting solutions that are community-driven. Yet, if somebody objects to access these mechanisms, which I don't call transitional in my minority position, but I know the majority. But if these systems do not work, you need to have resort to something else, because otherwise these systems wouldn't be sustainable. Final speaker, of course, there was another speaker today, and actually she teaches the global war on terror. Am I right? In this very school and this very university, which is Michael, very independent in terms of academic. Because I've been teaching to my students for 12 years that maybe the United States Constitution should be amended, and I'm not even a citizen. Here we talk about the UAE, and we have NYU Abu Dhabi, and then we had Jennifer Tram bringing a master course here on the global war on terror, probably before the law school and other places. And Jennifer, she's the director of our concentration of human rights and international. It's the reason why I'm here, so I'm forever thankful to her. And she cannot be with us today because of a passport emergency. She's with me honoring the legacy on Sunday of prosecutor Ben Ferencz, who died at 103 years of age last year, and we are commemorating him at the Peace Palace in The Hague. And a US citizen cannot travel to The Hague without a passport. I can go to The Hague without documents because I'm all right. So final speaker actually comes from a country that recently left the EU. And as my students know, I'm obsessed by Brexit. I consider it the worst thing that happened in the last 15 years for international law, which inspired countries to withdraw from the ICC, to do every evil thing that we can consider as public international lawyers, close parentheses. So my friend here, he comes from London, all from London for this meeting. That's why he's the last speaker, the most important one, I believe. His name is Rodney Dixon. He's a King's Counsel, and he belongs to a chamber in London, from which also Mr. Prosecutor comes from. Am I correct? Or yes. was one of your colleagues, Mr. Karim Khan? He's still on the board. He's still on your board. So it's called, I didn't want to advertise your, it's not a firm, so it's called Temple Garden Chambers. Rodney is South African and came to The Hague with the first prosecutor of the ICTY and then on ICTR, the legendary Richard Goldstone, who, among others, incriminated Ratko Mladic and Radovan Karadzic, whom both are serving a life sentence on the basis of a final judgment for genocide in Srebrenica and other very serious international crimes that they committed during the war in former Yugoslavia. So just to cut a long story short, Rodney is also happening to be the lawyer of some of those involved in the situation in the United Arab Emirates. So, Rod, please, and I was with you recently at a conference where the widow of the late Jamal Khashoggi spoke, remembering what happened to his husband, a columnist of the Washington Post, who was killed when he tried to obtain some documents from a Saudi Arabia consulate in Istanbul. And I realized that Rodney was also involved in that case. Am I correct? So he's in so many other cases. He has also defended the bad guys, like the former head of the secret services of Gaddafi's regime, and Charles. Were you involved in Charles? No, not Charles. Okay, it was your colleague Karim Khan's. But anyway, Rod, thanks so much for being with us.
What an introduction. Thank you very much for the opportunity to speak, and I'll do it swiftly. I know time is moving on. From a practitioner's point of view, and as you say, having acted for and assisted some of those who have been detained in the UAE and their families, there are just 3 points that I wanted to highlight that have stood out in all of the work that has been undertaken. The first is the complete lack of any evidence ever that's assembled and put together to support the allegations. I mean, even if the allegations are not ones that amount to terrorism, any allegations of any criminal conduct. And as a result of that, what you therefore see, in order to be able to justify the sham proceedings, is the solitary confinement and the torture to get the convictions in place. You get them in place through getting confessions at the outset, which are then used as the primary evidence. But in going through all of these cases, all of the files, there's nothing there other than the confessions, and that's why we see the mistreatment. I think one, it's to punish. It's to send out a message, but it's also there to have something on the file to say, oh, well, the person admitted it. I acted for, you might have heard of a British academic, Matthew Hedgen, who was detained and tortured in 2018. And he was doing research, in fact, on these very issues, on state security, on counterterrorism, and the way it's used in the UAE. And he was accused of being a British spy working for MI6. This is the James Bond institution. And even though MI6 actually came out in publicly, which they never ever do, and said he's not a spy, they nevertheless persisted with it. But the only way they could justify it was a confession that they got from Matthew. And they used a similar pattern which has been reoccurring in many of these cases, including the trials that we've been talking about, of in the first period of detention, allowing almost no access to anyone. So it's a sort of shock of detention, where in that time, you get people to confess. I mean, Matthew confessed to be a British spy, even though he wasn't, because of the solitary confinement, the pressure that was put on, the lack of access. Then after about 6 to 8 weeks, they allowed the British embassy to have access to him. But by that stage, the damage was done. They had the confession. That has happened in a lot of these other cases that we've been talking about as well. And it's something that the special rapporteurs have picked up in their report, that there are a number of allegations of torture in order to get confessions, which then become the key evidence in the case, and which they can then say, well, you know, what do you expect us to do? We had to convict. But of course, you know, that leads to the second point that I want to make, which is that there's no ability whatsoever in any of these cases to genuinely challenge anything in the national system. It's a completely desperate situation that you face as somebody in the system, because there's just no way of raising any of these points. In Matthew's case, the only way in which he was ultimately able to be released was because of huge media and political pressure So instead of really conducting a legal case, I was really marshalling more of a PR campaign to get the British government to make phone calls to the top people in the UAE, and to do it all very publicly as well. What often they want is things to be done behind closed doors. The authorities will promise detainees, including many of those who are detained at the moment, that if you don't make a fuss, if you don't go to international lawyers, don't get people to talk out on your behalf, then there's a greater chance that you will be released. But it was quite the opposite in Matthew's case. It was the moment it became public. That was obviously a difficult decision to take, because you never know what the consequences are. But the moment it became public, it was then possible to get a release. But I mean, he's a foreigner. Those who are stuck in the 94 and then the 84 trials are local UAE dissidents, opponents, human rights defenders, and for them, that kind of exposure is not going to have the same effect. So the true desperation, as a highlight of not being able to use any means to challenge it within the system, really underscores what we've been talking about today, about the need to publicize it in the court of public opinion. But that is the only way, and I've seen that in some cases where it has been successful. That is the only way in which people can have some hope of there being a resolution. Even doing it, I know, gives the family some hope, and that's often important. The fact that it is publicized, that it is being talked about in places like this, means that people have something to hold on to, and they can keep going. You mustn't underestimate that from having direct contact with people, the enormous support that people can feel, even if they think, I'm not sure this is actually going to make a difference tomorrow, but knowing that there are people out there that are focusing on it, who are talking about it, and ask people to go on, and that energy can then lead to something further down the line. Otherwise, you can end up in a very dark place. So important to use all of the mechanisms outside, as has been happening with the UN procedures, and we've seen the special rapporteurs referring to a number of reports that they've been getting, communications that they receive, that they can then make public, and they can use then to send back, as they did in the recent communication from January that they sent to the UAE authorities. And then the third matter that I wanted to raise, which I've also seen reoccurring, is the use of red notices, and here in particular Interpol, and to some extent control of Interpol, to be able to track where people are going and make sure that they can get people back into the country. So this is a very important aspect that we haven't focused on much, how there is a concerted campaign to search around the world for people and wherever they might be, and to bring them back in. So you don't have dissidents abroad campaigning, and the ability to, in that way, galvanize more support, track people down, try and lure them into places where they can be arrested and bring them back, using all kinds of methods, often pressure, because there are family members in the country. But then the red notice system. And one of the cases that we were involved in was when the current president of Interpol, General Al-Raisi, who is the Inspector General of the UAE Ministry of Interior, he was the person in charge of, and still is in fact in charge of overseeing the conduct of persons in prison. It's his responsibility to deal with any complaints, to ensure that there is proper respect for human rights in the prison and judicial system. That's his role as the Inspector General. He was appointed as the president of the International Police Force in November 2021. There were a lot of people who spoke out against that, but he got it through and is in that position still today. And in fact, very shortly after he was elected into that position, there was another case that arose that I've been involved in where a Bahraini dissident was arrested in Serbia on a red notice. And even though we got an injunction from the European Court of Human Rights to say, don't transfer this person to Bahrain, they maintained they hadn't received the order from the European Court and sent him to Bahrain, where he's serving a life sentence. And that was all on a Interpol red notice. And in fact, the Serbian authorities used that to justify why it had happened. And the interesting thing was that it's been widely reported, he was flown from Serbia on a UAE jet to Bahrain, so picked up, flown to Bahrain. And many people have therefore questioned, how much coordination is there going on between these different countries? I think a lot more than we fully realize, and also I think very often the same practices and methods are being used. So that's another very recent case which has been challenged in the European Court of Human Rights. So there is an outlet there, but once again, in Bahrain, absolutely nothing can be done to seek to challenge that lifelong imprisonment. So those are just a few of the very practical things I've come across, practicing in this area that stand out. What I wanted just to end off with was what the UAE actually said in response to the special rapporteur's January communication. They came back, in fact, and I think it's all public on the webpage now, on the 8th of April, with a very generic response. I think this is another theme is whenever they ask to reply, they come back with these answers that are almost impossible to work out what they're saying, very jargonously, and don't actually address in any meaningful way the allegations that are being made. And when questions are put, there's no direct answer to them. It's a very short response, 6 pages, where one of the main things that they say to the special rapporteur is that this is all premature. They say, don't jump the gun. We haven't even heard the defenses yet. The judges haven't even deliberated and provided their reasons interpreting the law. And there's been no appeal yet either. So don't prematurely judge us. There's a long way to go. So, perhaps that's where we should place the major challenge to the authorities now. If you say it's going to be done properly this time, well, how? It has to be transparent. It has to be international involvement. The national procedures can't be trusted given the track record. So put your money where your mouth is now. If you're saying that you've been criticized too soon, well, we'll show how it can be done properly and open it up for everyone to see.
Thank you very much. And I think you gave us some sort of insight of another avenue, of another strategy where maybe all the ideas that Honorable Ridgway and Human Rights Watch and others have been putting on the table could be, united under the same strategy, sort of challenging the authority of one state that declares, I'm ready to do something maybe different from what you accuse me to be doing. And so let's see. What I would like, I think we exhausted our time. What I would like, however, to ask you is maybe a 1 minute last round, especially those who traveled from far away and those who are in New York but are often traveling to the Middle East. Do you think there is a way to move out of this counter-terrorism consensus? Can this be a topic that at least can be discussed? Or it's an absolute taboo because the vested interests and the players are there all, let's say, all in the ranking, and they will follow the structures that they exist. I try to put on the table something provocative because I think the red notices could be challenged by the fact that they are not legally binding, even though they have an enormous influence. So what you say is absolutely correct. But unfortunately, in the absence of a universally accepted definition of what terrorism is, we run the risk of these abuses. And these abuses continue. And they unfortunately proliferated after 9/11. This is maybe the only 2 words that Jennifer would have said for sure. And she's not with us now. I need to say this, that so many, and when President Biden urged after the 7-8 October attacks, urged President Netanyahu, don't do the same mistakes we made after 9/11, probably he referred to the entire global war on terror and what happened around that, including Iraq and so on. So if that is a topic, and maybe Kyle, you should be the first to give a shot on this, and I see a booklet that on preventing and countering violent extremism. So
Yeah, I worked with David on this. It's on our website, but it's about how to prevent violent extremism. Listen, I hate to be realistic, but at the political level, the UN Security Council is more paralyzed and fighting in blocks than ever before. The geopolitical situation is extremely dire. And we see countries like China backing Russia to invade Ukraine. They're taking Ukrainian children against the Genocide Convention. There's all sorts of stuff going on. So I don't necessarily think that the states are right now going to be able to do it. There's a role for civil society to get started, yes. But I'm a little pessimistic right now, and I don't think I'm probably alone in this field.
thank you, Kyle. Yumo, you want to add something on this?
I'm with Cal with
Yes.
how it is politically at the regional as well as international levels. I think if we're going to move away from seeing it as very militaristic, we might be, or we should be open to having non-military actors in the security framework and actually wanting to actually sponsor and finance some of these non-military strategies, and that's not going to happen anytime soon, unfortunately.
So maybe Michael and Rod, what about giving priority to human rights while countering terrorism? How can we do that in 1 minute, each of you? Michael. No, Michael, you are the biggest human rights organization in the planet after Amnesty International.
I think all I wanted to say is that I think we judge other contexts in which there's violence, including areas of conflict under international humanitarian law. And when states are carrying out abuses, we have a framework that is hundreds of years old to judge them, and we also apply those to armed groups. I think the problem with terrorism is that we see it particularly in non-conflict contexts, things that we're talking about, UAE, Saudi Arabia, is that it's so warped from any type of meaning towards violence, terrorism, attacks on civilians, that it essentially becomes functionally useless and suited only to essentially justify kind of mass arrests, et cetera. So it's such a problem in just, again, speaking of the context of authoritarian countries, as well as ones in which the US has often justified it as well. So I don't want to just focus on the Middle East. So I guess why should particularly international legal law clinics, individuals, commentators give it such weight? Shouldn't we be moving away from it and criticizing it more? That's all.
Very good. And the last two interventions, Rod and the Honorable Ridgway.
Well, I would just reiterate that and say, focus on it as crimes against humanity outside of an armed conflict situation.
Very good.
There's a convention that's been discussed on that, but look at ways in which that can be taken up under universal jurisdiction as well. But also want to encourage anyone else to ask any questions. I don't know if we have 2 minutes for that.
I think that should be the final word.
All right. So are there any questions before that I say that was the final word? Any questions? Okay. So let me just say only one thing, which is to say international law is there and it's there to stay. And maybe the United Arab Emirates didn't ratify the International Covenant on Civil and Political Rights for a reason, but they are still bound by customary law. They are still a United Nations member state. They are still undersigned the Universal Declaration of Human Rights, which reflects largely customary law. And so let's make this case much more visible and let's maybe be concrete. Like this case, there may be many others in other regions. Let's learn from good practices like the one that Humo presented regarding Nigeria, but I think we have a lot of work to do. Thank you very much for having been with us.